Good morning, everybody. Thank you for attending. I'll try to stay on time here. So this morning we're going to be talking about protecting inherited assets with discretionary trusts in prenuptial and postnuptial agreements. Before we start, I just want to introduce a few people from McLane Middleton that are in the room. My colleagues Jesse Angley, David Moynihan, and Eric Sigmund are in the back. Thanks, guys, for coming. To my left is Joel Sherman is here as well.
And Bill Zorn.
Bill Zorn is here as well. Thank you, George. All right.
Is anybody?
Present. Okay. To my left is George Cushing. Many of you probably know George. He's been in the trust and estates world for longer than I have. And
Lives in being plus.
21, 22, I think it's 21. So we focus on trust and estates here at McLane Middleton. We have a very good sized trust and estates department. It's a really big part of what we do at the firm. So you've been to these events. Many of you have been to these events before. We try to hit timely, interesting topics within the trust and estates world. And today's is particularly timely, given a case that came down in August regarding the issue we're going to be talking about today.
Before we get into this, though, I think I should introduce my co-panelist. This is Ryan Swartz. He's recently become a director of the firm, and he's a really very, very strong trust and estates lawyer, so I hope you'll all get to know him better over the years.
So just an overview of today's presentation. We'll be discussing the use of trusts to protect an inheritance or trust assets in a divorce proceeding. We're going to give a lot of attention to the recent Pfannenstiel case. A lot of these seminal cases have very interesting names. We have the Crummy case, the Pfannenstiel case. We need more Smiths.
Smith and Jones.
Smith and Jones. We're going to talk about the ideal structure given the case for divorce protection for trust assets. We'll discuss using trusts for descendants to require prenuptial agreements, prenuptial agreements, postnuptial agreements, and then we'll finish with self-settled domestic asset protection trusts. It's important to distinguish between two different things, self-protection versus third-party protection, and sometimes it's easy to blur the line. Self-protection relates to clients entering into agreements or trusts to protect their own assets in the event that they get divorced. So client says, I have assets, I'm concerned about divorce, what can I do to prevent my assets from being allocated in a divorce proceeding? And in that arena, we have prenuptial agreements, postnuptial agreements, and domestic asset protection trusts. That's to be distinguished from third-party protection, i.e. the creator of a trust wants to protect assets for others, i.e. children and further descendants, in the event that the child/descendant gets divorced. So we'll talk about trusts for the benefit of children during the settlor's lifetime, and also trusts for the benefit of children upon the settlor's death.
And what we're talking about is irrevocable trusts. In other words, trusts which you set up for a specific class of beneficiaries and which, in theory, can't be modified by the beneficiaries themselves, although there are a lot of new rules that make that more possible.
So the issue is this: this client comes into the office and says, how do I protect my child's inheritance from being diminished in a divorce proceeding? So client leaves assets to child, the child later gets divorced. What can the child do? What can the client do to ensure that the child's inheritance is not subject to division in a divorce proceeding? And this relates to family law in Massachusetts, in particular, Mass General Laws, Chapter 208, Section 34. That's the statute that says that a divorce court the probate family court may assign to either the husband or the wife all or any part of the estate of the other. And there are a whole list of factors that go into how a judge might allocate assets between the two spouses. And of course, this assumes that the parties have not been able to settle. Most cases do settle, but when it comes, when they can't settle, it comes to the judge, and the judge decides how to divide the assets. And it's important to remember that Massachusetts is not a 50-50 state. A lot of people come to us and say, well, if I get divorced, it's 50-50, it's 50-50. That's not necessarily the case. There are some states, mostly out west, that are what are called community property states, where it is strictly 50-50. Massachusetts is a marital estate state where there's a whole list of factors that go into dividing the assets. It may not be 50-50.
And in addition to the factors that the judge uses in exercising the equitable distribution concept, there's a determination of what assets are marital assets and what assets are not. And the concept of a marital asset is it's an asset that's used in the marriage. And there are things which could be not used in the marriage. But most times the court is looking at all of the property of the parties as being marital assets, and you have to really establish that they're not.
So this is a fairly simple concept. There's no protection for outright distributions. What I mean by that is, the client sets up a trust. The trust provides that upon the client's death, assets pass outright to the children. So the client dies, debts, expenses, taxes get paid. There's a pool of money remaining to be distributed to the beneficiaries. And the trustee cuts checks to each of the children and says, here's your money, good luck, my job is done. In that case, once the money comes into the child's hands, it's subject to the child's liabilities, including a divorce. So wherever we have cases where there's an outright distribution, it's important for the clients to understand that offers no divorce protection, as well as what are called staggered distributions. A lot of clients with younger children, younger beneficiaries, set up trusts where upon the client's death, the assets are held in trust, and then there are a series of outright distributions that take place. For example, 1/2 of the assets are distributed to the child at age 30, the balance might be distributed at age 40. In that case, as the money comes out, it becomes subject to the child's liabilities. So many clients leave assets to children in trust for the child's lifetime. And those trusts typically include what's called a spendthrift provision, which is really a key part of this area of law. A spendthrift provision is a provision in a trust that prevents a beneficiary from assigning his or her beneficial interest in the trust to anybody, and it provides that the beneficiary's interest shall not be subject to attachment by creditors. So you may think, well, if there's a spendthrift provision in the trust and the interest is not subject to creditors, why are we discussing this? The concept of a spendthrift provision, unfortunately, has been slowly eroded through the years. I believe it started with the ERISA enactment, and that's been really a basis for why it's been diminished.
ERISA was enacted in 1974 to create some kind of systematic fairness in retirement plans. And it contains a lot of different provisions, but one of the provisions is that an ERISA plan is a trust, and it's a trust that's subject to a spendthrift provision, which means that the creditors of the participant can't reach the property. However, in the first case that came down, it was a claim by a wife during a divorce to a share in a plan that wasn't yet ripe for distribution because the person was in their 50s. And the judge said, the spendthrift provision was never designed to prevent legitimate spousal claims against the participant. Yes, it was. It was designed to keep the assets in the trust, not being drawn out unexpectedly and contrary to the rules. But that became the standard that was going on in the federal courts dealing with ERISA issues, and it's leaked into the area of state law. I will say that there are 50 states in this country, and only 2 of them give this kind of access to trust assets through this kind of case that we're about to talk about. The other one, I think, is Oregon, but most states do not allow interest in trust to become part of the marital estate unless there's an awfully good argument that this is different from a normal trust arrangement.
So clients leave assets to children in trust, and the issue is whether the beneficial interest in the trust is subject to equitable division in a divorce. And that issue is not defined by statute. The statute refers to the word estate. And there are examples within the statute of types of assets that are part of the estate, but that term is mostly interpreted by our courts. And this is an area where it's been subject to court interpretation, and there have been a good number of cases in this area that have addressed this topic. There's a case from 1991 which said that a beneficiary's interest in a spendthrift trust can be present if it's present, enforceable, and valuable is an asset subject to equitable division. And for many years, the really preeminent case that we used as guidance in this area was DL versus GL, a 2004 case that involved 7 trusts, and the wife and husband were getting divorced, and the wife argued that the husband's interest in these 7 trusts should be included in the marital estate and subject to marital division. In one of the trusts, the husband was the sole beneficiary, and there was an independent trustee, and the trustee had sole and uncontrolled discretion to make distributions to the husband. The court concluded that the husband did not have a present enforceable right to the trust because distributions were the sole, uncontrolled discretion of the trustee. 6 of the trusts involved multiple generation trusts where the husband was just one of many different beneficiaries, including grandchildren, great-grandchildren. And the issue in that, for those trusts, was upon the termination of the trust, the husband was going to get a share of the trust, but his receipt of the trust assets was conditioned upon him surviving his father. His father was still alive. And the court said, because your husband could die before his father dies, his interest in the trust is too remote to be included in the marital estate. So we use this case quite frequently when advising clients as to how to structure their trusts to ensure that their children's inheritance was protected in the divorce proceeding. And then came the case of Pfannenstiel versus Pfannenstiel, which was ruled on August 27th, 2015. And it's really been the buzz of the trust and estates community since then. It's provided some further guidance on what we thought was the case for many years.
Now, this is 2015, and this case went to trial in 2010. It was decided by the court, by Judge Ordonez, who is now the chief judge of the probate court system. And in addition, it went to the appeals court and sat there for almost a year and a half since the argument in order to get to this point. So I think we have to regard this as a very tough case for a decision by the court. And it's now pending appeal in the Supreme Judicial Court. They don't have to take it. And my guess is they're not going to take it because it's such a tough case, and they don't want to muddy any further the water that's already been muddied considerably by this case.
It's really important to understand the facts of the case because they had a really big impact on the court's ruling. Kurt and Diane Pfannenstiel were married in 2000. They have 2 children, one with ADD and dyslexia, and the other child has Down syndrome. And so Diane gave up a position in the Army Reserve to care for the children. She spent a lot of time taking care of them, making sure that their needs were addressed. Kurt was the beneficiary, I'm sure is still the beneficiary, of a family trust established by his parents, and the trust was valued at approximately $25 million. And the trustee was making distributions of several $100,000, about $20,000 a month, to Kurt and to Kurt's siblings. And the court noted that these distributions enabled Kurt and Diane to live a, quote, upper middle class, unquote, lifestyle.
Excuse me, was a family trustee or?
That's one of the important facts, and we're just going through the different elements, but that is the truth. It was a brother, a twin brother, and a family lawyer for the father. The family lawyer for the father was described in the opinion as having a, quote, hands-off approach. So the brother was basically carrying the burden of distributing. And the distributions are made equally to the 3 siblings, and no distributions are made to anybody else.
The trust did include a spendthrift provision, and what was really perfect segue.
Sorry.
Yeah, that's okay. So, really, what was critical is when Kurt filed for divorce, the distributions stopped immediately, and they continued for his siblings. And the court didn't like that. They said that the cessation of the distributions to Kurt was a deliberate manipulation to silence his interest in the trust for a convenient time while the divorce was ongoing. the trust included what's called an ascertainable standard, which is a term of art, and it's a term that you could write a book on. It's a technical tax term that relates to how a trustee makes distributions to beneficiaries and the standards by which the trustee should follow when considering whether or not to make a distribution. For example, health, education, maintenance, and support. That language, HEMS, may be in the trust document, and it has a very specific reason for being there. And in this case, the trust did include an ascertainable standard to provide for the comfortable support, health, maintenance, welfare, and education of each or all of the members of such class. An ascertainable standard is used for technical tax reasons, specifically where a client says, I want to leave assets to my children, I want those assets to stay in trust for the child's lifetime. One of the reasons to do that is to ensure that the trust assets are not included in the child's estate for estate tax purposes upon the child's death. So assets can grow significantly free of estate tax as generations pass away. When you have a fully discretionary trust where there's no ascertainable standard and the beneficiary is serving as trustee, that's the equivalent of full control. So the IRS says, you're the trustee, you're the beneficiary, you can withdraw for any purpose, the money is yours, therefore it should be included in your taxable estate. When you insert an ascertainable standard, it takes just enough control out of the beneficiary / trustee's hands for the IRS to say it's not included in your estate. And there are also income tax reasons why an ascertainable standard is used.
The purpose of this clause in your trust is to keep the assets subject to the son's or the daughter's control as trustee without adverse tax consequences. Unfortunately, most clients think that it's better to have their family members run the show than it is to have an independent trustee. This case illustrates how that may not always be the case. And I think it's going to be very important in drafting documents in the future. And we're doing it more and more now, not for tax purposes, to protect people from estate taxes, because the estate tax exemptions have gotten very substantial. But we're doing it a lot more to look at these family issues and creditor issues so that people understand that it isn't just tying up money that the family can't reach, it's also protecting the money from many of the normal vicissitudes of life, including divorce.
So the court found that the value of Kurt's share in the trust was in fact subject to division in the divorce proceeding, and that approximately 1/2 of his share of the trust should be transferred to Diane. What's interesting is there were 3 children, 8 grandchildren. Distributions were going out to the 3 children. I don't believe the grandchildren had ever received a distribution. And in a ruling that was favorable to Kurt, the court said, you have 11 beneficiaries, we're going to take the value of the trust, divide it by 11, and that number is the value of Kurt's beneficial interest in the trust. Now, when you have multi-generational trusts, trustee discretion, equal or unequal distributions, there may be a question as to whether that methodology is correct, but it was beneficial to Kurt because the court could have said distributions going to the 3, no distributions are going to the 8 grandchildren, we're going to cut the trust into 3 equal shares, and that 1/3 share is the value of Kurt's share. That didn't happen.
And it's normal in dealing with families that there be shares for each branch of the family that pass down to the children and greater and more remote descendants over time. This is what they call a pot trust. In other words, a single pot out of which distributions can be made to anybody, although most trustees in dealing with those kinds of distributions think of it as a stirpable distribution. And I've been watching this for a long time from the sidelines, but that's generally the way professional trustees regard these things. But I think he did catch a break because the amount of the value of $25 million could have resulted in a determination that he and his family had an $8 million asset there.
Now, it's important to note that this ruling does not mean that the judge went into the trust, pulled money out, and divvied it up between Kurt and Diane. And there was no order to the trustee to make a large distribution out to Diane. How it works is that basically the court says, this is the value of Kurt's share, this is how much we're going to allocate to Diane, and now Kurt has to make a series of payments in order to fill up the value of Diane's interest in the trust. So just remember that the trust funds are not coming out and going to Diane. It's really Kurt being given a number and the court saying, you have to pay this number over time to satisfy that award.
Yes?
If the value of the trust changes from the documents that were prepared, let's say the trust goes down, or there are additional grandchildren, so the value for, say, Diane goes down, does that also apply?
Well, in dealing with the determination of the shares of the parties, they pick a moment in time. Trusts always are changing in value, going up and going down. And that's a mechanical issue that never can be addressed at all if you constantly are revaluing the shares. They're not able to divide the trust and give the wife a share of the trust. If they could, they wouldn't have to worry about values changing because that would be taken care of automatically by the fact that there was a share. But they fix the value and they say it's worth $2,230,000, and so your share is $1,100,000 and whatever. And then order him to pay that amount to her over time. In this case, it was done in a series of monthly payments of $48,000 and change for 24 months. Where he was going to get the money if the trust didn't help him, I don't know, and that obviously was what the judge had in mind. And in fact, part of this case relates to the order of the court that he used his best efforts to persuade the trustee to give him the money. And the court determined that he hadn't done that, and therefore they held him in contempt. And it's reported that he was put in handcuffs and about to be taken away to jail when he missed these payments until his sister showed up and gave a check for $300,000 or $400,000 to the lawyers to the other side to satisfy the arrearage. That contempt, which isn't really part of our discussion today, was dismissed at the appeals court level. They said that they thought he had acted in good faith and he had used reasonable evidence. So that's over. I mean, that had ended already. But that's the kind of drama that could go on in these things, because if you disobey a court order, you can be punished with contempt. And if you're punished with contempt and you don't satisfy the court that you're acting reasonably, they'll throw you in jail, and people do go to jail.
So the language that we really focus on as lawyers when advising our clients is the following language that the court used. The court said that Kurt's interest in the trust was vested in possession of a presently enforceable right to the trust distributions to support his lifestyle. What was really a key in this case was the fact that the trust involved had an ascertainable standard. It was not a fully discretionary trust. Again, a fully discretionary trust says exactly that. Distributions are in the sole and uncontrolled discretion of the trustee. There is no ascertainable standard. This case involved an ascertainable standard, and the court noted that. It said that an ascertainable standard differs from a wholly discretionary trust, with no distribution standards regarding support, health, maintenance, welfare, or education. With an ascertainable standard, there is a more enforceable right to trust distributions.
Right, and I think that's really the key thing. There have been a number of cases over the years about what trustees should do when they're faced with a responsibility to provide for health, education, support. They're required to investigate, to keep in touch with the beneficiary, to understand the beneficiary's lifestyle, to understand the needs as they arise, not to throw money at the beneficiary, but to meet basic support needs. There's some concept of a standard of living. One of the key issues seems to be that the trustee shouldn't be encouraging the beneficiaries to increase their standard of living. And if they do, are they then bound to continue to support that lifestyle? A lot of questions on all those fronts. The key factor is that if you are a beneficiary of a trust with a needs standard, and we call this a needs standard because it's not fully discretionary, you can enforce discretionary trusts too, but if the court gives, if the trust gives the trustee broad discretion, the main argument is going to be the trustee isn't treating me fairly, not that you didn't provide for my needs, you wouldn't get me a new car, you wouldn't help me with my mortgage payments. those are all objective facts which can be shown to the court, and you can say, this is what he did for me, and he isn't doing enough. And that's a very big difference, and that's why they said that Kurt had enforceable rights, and those rights, in effect, became marital assets that his wife could then seek to use in satisfying her support needs after the divorce.
And if they do that, is it just the amount that's coming out like each year? It could be a $25 million trust. If it earns, say, 10% or 8%, it earns $2 million each year. If distributions to the three kids are, say, plus 600.
Right.
All they got was 600,000 a year. They can't use the whole thing.
That's true, and I think there's two different elements in the divorce. We're talking about the section that permits the judge to divide the marital property between the husband and the wife. There's also a determination of alimony, and that's an income question. And you can also look at the alimony issue in a case like this. If the trust assets are being divided, then theoretically, the spouse who is getting the money out, and that's not the beneficiary, having her income need met from the share of the trust that she gets, and there's no additional income component from the trust. If they determine it wasn't a marital asset, but the husband was receiving the income, then they might say he has to give her half of the income he gets from the trust as his alimony contribution. Alimony is different from property divisions because it's subject to income tax, and property divisions are not. It also terminates on remarriage, and it may also terminate on retirement. So, but property division is a one-time thing. So these are all elements. The Pfannenstiel case did not deal with alimony, so we don't know what alimony aspects were involved, if any. Marshall.
Hi. I had to deal with the ascertainable standard in a divorce case about 10 years ago, and we were trying to argue exactly what you suggest, that ascertainable standard creates some rights in the beneficiary that were enforceable. But at that time, the farthest I could get to that was that there was a duty on the trustee to investigate the need and the lifestyle and all that sort of thing. But once the trustee had made that investigation, the trustee was then still free to determine the trustee's discretion not to make a distribution. And I guess it just seems to me that this is taking that duty to investigate and to look into the needs of the beneficiary, at least in the divorce setting, and in the context of pattern of distributions, saying that that's vested in possession. It seems to me those words vested in possession don't really apply from a trust law perspective. It's really something that's just happening in the divorce setting.
I think that's a good point. I think that in this case, if you look at the opinions, they talked about the subterfuge. They talked, relying on the spendthrift provision as a subterfuge, and then talking about manipulation. Those two things suggest the court was really bothered by the fact that even though there was this duty to have examined things, nobody looked at anything. They were sending $20,000 a month to this fellow. He was also working as an assistant bookstore manager for the company that was providing the income through the trust in terms of profits. He was making $170,000 a year for being a bookstore manager, which the court found was a job that would normally provide a salary of $55,000 to $60,000 a year. So he's being paid about 2 or 3 times what he should have been getting. So his needs for support may have been far less than his actual spending. And for the court to say all those things suggests that they're looking hard at whether the trust is being administered the way a trust should be administered. And I think as a general proposition in these cases, if you have trusts that are not being administered properly, you're going to find much more vulnerability. But that's going to be a hard one to sell to people who are administering trusts that they haven't had the problem arise. So then we're going to talk about what other things you can do to protect yourself against that argument by getting a waiver in advance from the potential claimant.
Yeah, I think it's very much like the tax situation where, the documents can be perfect, but the facts on the ground will defeat the strategy.
Well, clients pay us a lot of money to draft trusts. And, I don't know how many clients have actually read through the trust from beginning to end. And I don't know how many of them have really thought about the issue of whether they really want to have a professional trustee. Most of them say, oh, that's expensive. Most of them have their accounts, invested in mutual funds where they're paying 1 to 1.5% per year in cost. I just don't understand the cost argument. They don't see it, but it's not because it isn't there.
And this illustrates the blending that occurs in every case of the facts and the law, and in this case in particular, the facts and the terms of the trust. And that was an issue that was raised in the dissent. 2 of the 5 judges dissented to the opinion, and they concluded that the interest in the trust was too speculative, too remote, too dependent on trustee discretion, too elusive a valuation to have been included. The 2 judges said, focus on the terms of the trust. The 3 judges focused considerably on the facts of the case, and it's hard to ignore the facts. They're certainly relevant to the ruling, but the 2 dissenters, in my opinion, had a good point. Focus on the terms of the trust when making this ruling, because you have to give trustees some amount of predictability when administering these things.
There's another approach that's taken sometimes in trust cases, and I think it's when the trust is being properly administered. It's a sharing of distributions when made. So rather than forcing a payoff of the value, you give an order that says if distributions are made to the beneficiary spouse, the other spouse gets a share of those. I think it's called when, as, and if. I'm not a divorce lawyer, but that was done in another case, Honig case. The problem with that from the point of view of the spouse is that when you have a discretionary trust, you can stop making distributions completely. And that beneficiary is not going to be barred from receiving other gifts from his parents, so the parents' assets aren't marital assets. So a when and if kind of distribution pattern can be avoided by the family if there are substantial resources by having the parents, provide the subsidy directly instead of it going through the trust. So I think there would be a reluctance on the part of courts in a situation like this to go that route. But there are, if the trust is being administered properly and they are making distributions, exercising discretion properly, that would be an alternate way that would be done, and that does occur in a number of cases.
So in light of this case, we are advising clients appropriately on how to structure their trusts, and quite frankly, it's very consistent between what we were telling them before and what we're telling them now. The more attenuated the interest between the beneficiary and the interest of the trust, the more likely that the interest will not be included in the marital estate. So we would have a fully discretionary trust with no ascertainable standard. In that, we have to balance this issue of asset protection and divorce protection with estate tax considerations, because you can't just say fully discretionary and then plug in the beneficiary as trustee. That has adverse estate tax and income tax consequences. Moreover, you wouldn't want the beneficiary to be trustee, because even if it was a fully discretionary trust, the beneficiary's trustee, the judge can say you have full control. So what we need is a fully independent trustee, and independent has a certain tax definition. But in this case, that definition got blurred because the independent trustee was the brother and the family lawyer, and the court noted that, they didn't like that. So I have a lot of clients who say, well, I'll just have my brother be the trustee, and if I'm worried about my marriage, I'll give him a call and say, don't send me any money. The trickier you get with these arrangements, the more likely they're going to be pulled into the marital estate. So fully independent trustee, unrelated, full discretion of the trustee, that's going to give the beneficiary the most amount of asset protection. And when we have these conversations with clients, we tell them what's involved in this kind of structure. A lot of clients like simplicity. They like the idea of passing away, leaving the assets to the children, and they're on their way. There is no ongoing trust. There is no controlling the inheritance from the grave. But with that kind of structure, there is no asset protection. So then we go through the options. We discuss using a fully discretionary trust for the child's lifetime. Who's going to be the trustee? Will it be an institutional trustee? Will it be an individual trustee? All of these issues are relevant to how much protection the child will have in a divorce proceeding. And again, facts, bad facts make bad case law. So we can be creative with these arrangements, but we of course have to advise our clients that the more creative we get, the better the argument someone may have. So I've had clients say, well, what if I have my child serve as co-trustee? And if there's a divorce on the horizon, the child will resign. We don't know. Pfannenstiel case and no other cases in Massachusetts have addressed that. There's been recent discussion among ACTEC members, the American College of Trust and Estates Council, about this case nationwide. It has caused a bit of a stir nationwide, and some have thought about the idea of decanting.
Decanting is a method of changing the terms of the trust, and in many states there's a statute that authorizes decanting to be done, and it prescribes who must be the trustee and what can be done and what can't be done. New Hampshire has a decanting statute. Massachusetts does not have a decanting statute, but in 2013, and we got a case from the Supreme Judicial Court involving the family of Robert Kraft. Mr. Kraft created a trust for his 4 sons in 1981, and he had a friend of his who was a professional acting as trustee, and the trust was a discretionary trust. It gave the trustee authorization to make distributions to or for the benefit of the family members as the trustee thought appropriate. And then 40 years later, the sons wanted to have more direct power and control over their shares of the trust, and so the trust was divided into 4 separate shares, and the professional trustee resigned, and each son was made sole trustee of his share. And because the trust had fully discretionary powers, one of the things that was done in the decanting was to limit the distributions to the support, maintenance, and education of the son and the son's descendants. And because we have a generation skipping tax on trusts that are created after 1985, but not on trusts created before 1985, and because this trust was created in 1981, they wanted to go through a court proceeding to make the modification with the approval of the court, determining that the law of Massachusetts allowed the modification so that the IRS wouldn't argue that the exemption from generation skipping tax had been lost by making the terms change in a way that would accentuate the generation skipping feature of the trust. And they were able to do that. So we have a law that says trustees can modify trusts if they have broad discretion. And that power allows trust to be changed. The problem in a case like this, however, is that this trust has limited power to make distributions. It's limited to support, health, and education. And that standard is not a broad standard. At the time of the Kraft case, the court asked for an amicus brief from the Boston Bar Association. And I was part of a team that put together the brief, and we suggested that there was discretion to make distributions to modify the trust. And decanting occurs by a transfer, an exercise of discretion from one trust to a new trust. Take the assets in the old trust, write a new trust, and then transfer the assets, and a decanted trust is the result, and all of the same attributes of the old trust apply in terms of taxes like generation skipping, exemption, and so forth. You get a different identification number, but that trust goes forward being operated in accordance with its terms. But we've said every trustee who has power to make distributions for the benefit of a beneficiary should be able to exercise this power, including if it's an ascertainable standard. They said no. Only if it's broad discretion. That makes it clear that the trustees conferred really the power to think about outside the box and do all kinds of things with limited discretion for health and education and support. You really are talking about pretty basic stuff, and modifying the trust in that way seems to us to be well beyond the scope of the discretion. So We don't think you can just decant this trust in Massachusetts, but you can move the trust to a different jurisdiction by changing the trustee. If you had a trustee who was resident in New Hampshire, for example, you could decant the trust under the New Hampshire statute. And the New Hampshire statute authorizes decantings for trusts with ascertainable standards. It restricts the scope of the decanting to some extent. You have to have the same standard in the decanted trust as you had in the original trust. So I'm not sure you could create the necessary change by decanting in this situation. And then the last piece is, supposing you wanted to decant, but the divorce was underway, could you do that and therefore defeat the claims of the spouse while you're going forward? I think that's very unlikely. That seems, we're talking about manipulative and using subterfuges, that just seems to me to be flying in the face of what the court would regard as good sense.
What's more interesting is, what if a client comes to you, client is beneficiary of a trust, beneficiary is also the trustee, there's an ascertainable standard for income and estate tax purposes, and the client says, I'm a little worried about my marriage. And under the Pfannenstiel case, we know that this trust would likely be susceptible to the divorce proceeding. So the client says, why don't I move the trust to New Hampshire, which has a decanting statute, we'll appoint a New Hampshire trustee, and the New Hampshire trustee will establish a recipient trust, and the assets will be decanted from an ascertainable standard trust into a fully discretionary trust. I will no longer be trustee, I'll have an independent trustee. A year later, client is divorced. What happens there? We don't know. But these are the issues that will come up, and for clients who are concerned enough about the possibility of divorce, it's something that could be considered.
We, by the way, normally, at least I, for clients of mine, I normally, if they want to have a child be trustee or co-trustee, I normally provide that the beneficiaries have the ability to add an independent trustee. And if they do add an independent trustee, the independent trustee becomes responsible for making determinations about distributions. And the scope of discretion is expanded from ascertainable standards to fully discretionary. So I think if you operate on that concept, that isn't manipulative. What you're trying to do is you're trying to save the cost of having an independent trustee. But if you need an independent trustee for any reason, you've got the mechanics already built into the trust, and then you can start operating the trust. And if you weren't doing it right before, you can start operating it correctly, and by the time the divorce happens, if it does, you're going to end up with a much better record of having had proper administration.
So you're saying if you have both trustee, the independent trustee so.
Well, normally, the question is, how is discretion exercised when you have two trustees? If it's an independent trustee and a co-trustee who's not an independent trustee, we normally provide that the independent trustee makes the decisions. That co-trustee is also a beneficiary. You don't want to have the beneficiary participating in decisions about distributions to himself or to beneficiaries he has an obligation to support. That causes some tax consequences. We normally also have the trust in separate shares so that each beneficiary is, each co-trustee is the primary beneficiary of his share. So we prevent him from participating in decisions. But on the other hand, I've never seen two trustees working together on any of these things that didn't talk about the issue of distributions. Sure, the independent trustee decides how much to distribute, but the other person is going to have input. And there's also input in non-distribution decisions like administration questions, investments, all kinds of things that don't necessarily lead directly to distributions but can affect the amounts, because investments produce income and that can affect the amount of available cash for distribution.
Can you talk a little bit about one of the points you got up there, the may versus shall? It seems to me that in this case, I don't think they talked about it enough.
I have a different view. My view is that in this case, shall means may. When you say shall in your discretion decide to distribute among this group, it seems to me it's the same thing. If it's shall in your discretion, it's not mandatory. Normally you say you shall distribute the income. That's a mandate. Shall in your discretion make distributions to and among the beneficiaries as you may deem appropriate for their support, etc. that is not quite a mandate. It's a mandate to do it, but only if you think it's appropriate.
Well, the court didn't, I don't think, catch that. The restatement of trusts says exactly what George said. Shall does not necessarily mean shall when you're giving a trustee sole and absolute discretion to make distributions. So if the trust says the trustee shall make distributions in his discretion, the trustee doesn't need to do anything, despite the word shall. The court, I don't think, caught that distinction, and they did reference the word shall as part of their finding. And so if we have a judge whose law clerk didn't find any statement of trusts in that section, that would help drive our drafting of trusts to the point where maybe we do want to use the word may, even though we're giving the trustees some discretion, we want to use the word may instead of shall.
I always use may. I don't like to use the word shall.
Right, I mean, in my experience, drafting using the word shall is exact. I mean, if you're gonna go with, my issue, I guess, is that an ascertainable standard is really just descriptive of what the trustee, of the amount. It's not, doesn't really talk about shall or may, right? We know that there are trusts that get drafted where you actually put ascertainable standards, you sort of throw it in the trunk, as in those situations where if I happen to not have an independent trustee, then I want this ascertainable standard to kick in because I need to protect it for state tax purposes.
That's right, and it's often in the back of the bus.
That's right. But in this context, the clause that was used was, I think, a lot more blurry than that, and it read in a way that, at least the way I read it, and based on the way I drafted trust, it said, you said shall distribute. And when you say shall, then you have, well, how much am I supposed to distribute? Well, you can have a mandatory income trust. That's one way to say you shall distribute all the income. But you can also say you shall distribute according to an ascertainable standard. And then it says, well, and it threw in the discretionary piece in there, almost as, in my mind, almost like an afterthought to say, well, yeah, we'll make that ascertainable standard a little bit discretionary, but it almost said, well, you can figure out what that ascertainable standard is. It's extraneous, right? Because that's what the job of the trustee is to figure out what this ascertainable standard amount is, right? And that's their discretion. And I kind of read it like, well, that's what the drafting was kind of weak that way, throwing that in there. But I don't know. I read the shall to be very, very instructive here, unfortunately for the
Well,
husband.
I think the judges did too. I think one of the things you have to recognize is that 80% of the cases that they handle are not trust cases or estate cases. And so many of the judges aren't very familiar with any of the subtleties of trust law, and they do rely on law clerks, but law clerks are beginning lawyers generally and don't have a lot of experience, and so it's hard to gather the necessary degree of focus on what really matters in trying to decide these cases. We need to move on because we have only about 10 minutes left, and we need to get you out by 9.
As George mentioned, the case has been appealed to the Massachusetts SJC, so please join us in 5 years to talk about it.
No, but that's discretionary. They do not have to take it. It's like a certiorari. They can say, no, we don't want that. So they don't know yet.
So this slide is a bit of a transition from this third-party protection concept to self-protection. We just wanted to note a provision that was sometimes used in our trusts, which is requiring beneficiaries to enter into prenuptial agreements before they get married, i.e. the client sets up a trust, and it's a lifetime trust for the benefit of the child. The trust says to any unmarried beneficiaries, before you get married, you shall be required to enter into a prenuptial agreement, and if you don't, distributions from the trust cease. Beneficiaries sometimes like that because the pressure is not on them as much to raise the issue with the prospective spouse. If distributions have been coming out, it's a lot easier to say, hey honey, let's do a prenup, because if we don't, the money's going to stop. Whereas if the money had just come out and the child's concerned about his or her inheritance, now you have to have the uncomfortable conversation, I want to do a prenup and it's all my idea. So we don't do this a lot, but we have had clients who insist on it. They're that concerned about their children losing their inheritance.
You're not stipulating the terms and conditions of the prenup.
No.
Satisfactory to it would normally be satisfactory to the trustee. And there are rules about what you have to do to make it enforceable. You want to make sure it's enforceable.
So it sounds like the trustee, not the child.
Well, the child has to be satisfied too, and it have to be satisfactory to the spouse and her attorney. But that would be a negotiation, and obviously the issue. We can talk a little bit about prenups in the next 4 or 5 minutes, but we're running out of time.
So now we move to self-protection, i.e. client has assets, client wants to protect his or her own assets in a divorce proceeding, and we have two options here: prenuptial agreements, i.e. prior to marriage, and then postnuptial agreements. And these agreements can cover a lot of different issues that have very little to do with estate planning, i.e. alimony, etc. But they also address real estate planning issues, and it's a popular misconception that prenups and postnups fall solely within the work of the family law attorney. That's not necessarily true. A lot of estate planning attorneys, including George, have a lot of experience in prenup and postnuptial agreements because they involve the same types of concepts that are involved in estate planning, i.e. what to do with assets in the event of divorce, in the event of death. Things like spousal waivers, portability, Q-tip elections, gift splitting. These issues can all be set forth in a prenup or a postnup.
And very often are, because when people are being limited in terms of what they can receive, you know, in a marital arrangement in the event of divorce, they want the assurance that they're not going to be giving up their independence, their financial independence, by getting married and maybe stopping work to have children, and then get slammed down the road and not have adequate support or resources. So very often you'll have a prenup that provides for insurance or specific benefits being provided down the road. And then you have questions that are elective, like, will you get married in your 70s or in your 80s and your spouse doesn't have much money? What about her exemption? You can marry her for her exemption. We have federal portability. If you have $10 million and you marry somebody with no money, you can create a $2 million savings in estate taxes for your family. And then, of course, the other side may say, well, pay me for my exemption. What's it worth to you? So there can be a lot of financial negotiation over these kinds of issues. And the point is, it's a negotiation. There isn't anything written in stone. The kind of agreement we're talking about here, though, is a kind of agreement we're writing a lot of. We have a number of clients who have set up trusts for their children, and we just did one about 6 months ago for a family where there were five different trusts for the benefit of the daughter, who was 25 years old. No distributions were being made to the daughter, but the big concern was that over time they would begin to distribute, and so the daughter's goal was, look, I didn't earn it, it isn't my money, I'm working, my husband's working, I just want to keep it off the table, I don't want that to come between us. And so the agreement only says assets which are inherited or gifted to me don't count in terms of divorce or inheritance. They're all separate. And didn't change. They agreed they wouldn't waive alimony. They agreed they wouldn't waive any claims regarding assets acquired during their marriage. And you know, if one was very successful, it's open for, you know, division in the event of a divorce. But the trust assets are off the table. And we're finding that a lot. It used to be I did a lot of agreements between marriages that were second marriages or even third marriages. And those were much more about making sure that the assets that were out there were kept separate, all of them, and that there was no alimony. But we're doing these now, and prenuptial agreements are required, as you know, by law to have separate counsel in Massachusetts and full and fair financial disclosure. And of course, when you do one of these things about trust, you have to describe the trust, you have to tell the other side what's in them, who the trustees are, what the distribution pattern has been. You also have to disclose what the income of each person is, what their liabilities are. It's a very, very substantial amount of information. Very often, these agreements have confidentiality agreements that say, talk about what's in the agreement with anybody except our lawyer. We won't be allowed to tell our other members of our family what my husband's or my wife's resources are, because people want privacy. Postnuptial agreements have been permitted since 2010. That's a little different situation. And the concern of the court is, if people are making a postnuptial agreement, is it really a postnuptial agreement designed to deal with property issues, or is it really a subterfuge for a divorce agreement? without one party knowing that the divorce is coming down their path. So you've got to be careful. There are additional scrutiny is going to be applied, and it really is going to raise questions about, particularly if the divorce begins shortly after the postnuptial agreement is signed. But these can be enforced as long as there's disclosure and there's counsel, and it's fairly clear from the circumstances that there's not an actual divorce plan.
Despite that, 10 years of marriage, you say to your spouse, maybe we should do a postnuptial agreement. Probably not gonna have a good impression. It's just me.
Well, I think it's interesting. I was talking with Doug Gomel, and he says that he runs a business called Business Continuity. I probably got it wrong, Doug, but they do a lot of consulting with families that own family businesses, and one of the things he said that they're doing is when the kids are getting married, they will sit them down and give them an understanding of what kind of things can happen in terms of marital agreements. And he says that it's educating them as, well, what's the playing field? Not you should or you shouldn't, but here are the issues, here's how to deal with it. And they're talking with them together as a couple and not, you need to do this versus you need to do that. And he says it's quite successful in terms of getting people into this process without it becoming acrimonious. And the big problem with any nuptial agreements is time. The time starts, when do people think about it? Well, they should think about it a year ahead. Often, though, they don't think about it till 6 or 8 weeks ahead. You can't, it's like a ship, you can't just stop it on a dime or turn it. You have to get it going, and then there's a process. They have to have good lawyers. I was in a situation a year ago where we had a father saying, I've got a $40 million real estate empire, and I've got 2 children, and if you don't enter into an agreement, I'm not going to leave you any of my property. So the daughter is in a position where she doesn't want to do this because it's going to affect her relationship, and her husband, to-be, doesn't want to do it because he doesn't want to do it. So he hires a lawyer, and the lawyer says, oh, we don't have enough time. This is 4 weeks before the marriage now. We don't have, it takes him 4 weeks to find a lawyer, and then the lawyer says, we don't have enough time. I won't do that. It's malpractice. I don't think it is, but that's the kind of thing that comes up. So he says, okay, no marital agreement, no inheritance. Okay, we can do a postnuptial. So I said, okay, all your husband has to do is hire a lawyer, and we can start that process. It's been a month, it's been a year. He's never hired a lawyer.
People want to do it.
It's cruising down the road toward disaster. Let's wrap up. We're talking about this last thing, which I think is a nice little trip.
Right, so instead of having to do a prenuptial agreement, a client could consider a domestic asset protection trust. Massachusetts does not recognize asset protection trusts. We do not have an asset protection statute. We have a long-standing case, Ware v. Gould from 1954, that says you cannot put your assets beyond the reach of your creditors while retaining a beneficial interest in the trust. You can't have your cake and eat it too. However, in recent years, some states have enacted asset protection statutes, which says the exact opposite. So you can put your assets into a trust for your benefit while protecting those assets from your creditors. New Hampshire is one such state that has an asset protection statute. It was enacted in 2009, and we've been using them quite frequently for multiple purposes, one of which is divorce protection. In New Hampshire, the trust needs to be irrevocable. It needs to have a spendthrift provision. Not surprisingly, New Hampshire law must apply. And there must be a New Hampshire trustee other than the person establishing the trust. In an asset protection trust, the creator of the trust can have the right to receive discretionary distributions of income and principal at the trustee's discretion. There are certain powers that the creator of the trust can have. For example, if there were multiple beneficiaries and the trustee wanted to make a distribution to someone other than the creator of the trust, the creator has a veto power and can basically stop that distribution from occurring. The creator of the trust can have a limited power of appointment, where that person can direct where the property goes upon the client's death. And the creator of the trust can remove and replace trustees. There are certain powers the creator can have, but because it's drafted under the requirements of the asset protection statute, creditors cannot access the trust assets. Now, there are certain exceptions to that.
Let me just make a comment. The reason for those veto powers and so forth is that when you set up an asset protection trust, although as the grantor you give up control of the assets, you don't want that to be transferred, treated as a taxable gift to anybody. So, you know, you put $5 million or $10 million into an asset protection trust and you make a taxable gift, all of a sudden you owe $2 million in gift taxes. That would be a bad thing. So the veto power is designed to prevent the gift from being completed until distributions actually occur from the trust to any third party. It's held there for the benefit of that person and then goes on as is agreeable to the person.
Now, this doesn't work if the client is already married. The client can't move to a postnuptial agreement, dump all his or her assets into an asset protection trust. Spouse, alimony, child support, they are exception creditors under the asset protection statute. I believe there's only one state, Nevada, that allows someone to transfer assets into a trust during divorce, during marriage, and still exempt them from a divorce proceeding. In New Hampshire, in most states, this is a strategy that is used well before the marriage. So the client's in his or her 20s and is doing very well, accumulating assets, and that person says, I want to make sure that if I get divorced someday, if I get married someday and I get divorced, my assets are protected. The client can put the assets into an asset protection trust. There's no need to do a prenuptial agreement because those assets will be protected in a divorce proceeding, and that's a strategy that can be used in lieu of a prenuptial agreement. And certainly if it's done years in advance, then it's not being introduced into the relationship like a prenuptial is. So some clients like that idea. It's a little less intrusive, it's a little less controversial, and it's something that we can do in many states, including New Hampshire. So we're at 9:03, not bad. We covered a lot of information. If any of you want today's PowerPoint, give me your card and we'll email it to you. Thank you all for coming. Appreciate it.